Hello friends, in the series on the income tax cases, today we will discuss a very important case of Shrimati Kuni, Sahoo and others versus Union of India and others. This case has been reported in 457 ITR at page number 777 and the matter has been decided by ORISSA High Court. The date of the judgment is 30th January 2023. In this case, the issue before the ORISSA High Court was that whether TDS is to be deducted by the insurance company on the payment of interest on the compensation regarding motor accident claims to be deposited with the Motor Accident Claims Tribunal. For understanding this concept, first of all, this is to be understood that whether the interest received on compensation in the motor accidents is taxable or not. For this, there is section 56 subsection 2 clause 8 which categorically mentions that interest on any compensation regarding the motor vehicle accidents is taxable. Apart from that, there is section 145 capital A clause B which says that the interest will be taxed in the year in which it will be received, because there is generally a dispute by the assessee that the interest should be spread over a period of time. But in spite of these two sections, the Bombay High Court in a very famous case, Rupesh Rashmikant, it has said that the amount is taxable only when it is in the nature of interest. And in that case, the definition of interest which is given in section 2, clause 28A was discussed. If we read the definition of interest, it says that the question of interest arises in a case when the money is given on loan or the money is borrowed. So, if in this case, the assessee has not given any loan to the insurance company, then the question of deducting the TDS on the interest does not arise. Although the terminology given is interest, but it is not in the nature of the interest. Basically it is in the nature of the compensation itself. So in this case, it was the plea of the assessee that the TDS should not have been deducted on my payment of interest by the National Insurance Company Limited. The assessee also took the shelter of section 194A subsection 3 in which it is said that the interest is to be deducted, the TDS is to be deducted on the interest only if the interest payment is exceeding rupees 50,000 in a year. In the present case, the interest was not more than 50,000 in a year. So it was the plea of the assessee that TDS should not have been deducted, and whatever the TDS has been deducted by the National Insurance Company, that should be refunded to him. When this matter came before the ORISSA High Court said that by taking the sole of the motor accidents claim, the claim is given to a person just to compensate him for any earnings which have been foregone to the family or to the person to whom the claim is given, for the future loss of the income, for the agony which he bears due to incapacitated of the any body part of the assessee. So it will also be inhuman that if any tax is collected by the income tax department on that interest. So by taking the shelter of the Rupesh Rashmikant case of the Bombay High Court and section 194 capital A subsection 3 which says that the interest is to be paid if this amount is exceeding 50,000 rupees, then the TDS is to be deducted. Because in this case the amount was not exceeding 50,000 rupees, so there was no requirement of TDS, and the insurance company and the income tax department has collected this amount without the permission of the law. So the court gave the order to the income tax department to refund this amount of TDS to the assessee. Friends, this case is very important. Although this issue is before the Supreme Court in some another case, whether this amount is taxable in the hands of the assessee or not. But if some assessees have filed the return, they can file the application under section 154 by taking the shelter of this case, by taking the shelter of the Rumesh Rashmikant case. If the case will go in favor of the assessee, then the assessee will be in a position to entitled to get the refund of the tax which the assessee has given on the interest on the compensation. Friends, this case is very, very important. This case is worth reading. At the end of this video, once again I am repeating the name of the case. The name of the case is Shrimati Kuni Sahoo and others versus Union of India and others. And this case has been reported in 457 ITR at page number 777. The matter has been decided by Honorable Orissa High Court and the date of the judgment is 30th January 2023. Thank you, friends.